We're going to get underway, and I'm going to just introduce you. And before we get underway, I'd like to thank everyone in the room with us and also those of you who are online coming along to this Law and Business Seminar of the Centre for Commercial Law and Regulatory Studies, or CLARS. I'm Jennifer Hill. And before we get underway, I just wish to acknowledge the people of the Kulin Nations on whose land we're gathered today and pay my respects to their elders, past and present. We're very fortunate to have as a visitor to Monash Law School and to CLARS, Professor Wen-Yeu Wang, who is one of the most eminent academics in the field of corporate commercial law in the world and certainly in Asia. Professor Wang is going to be visiting with us for several weeks. His background is he did his undergraduate studies at National Taiwan University, and he has an LLM from Columbia University and a JSD from Stanford University. And he's been teaching at National Taiwan University since 1995. He's practiced law in the United States at Sullivan and Cromwell and in Taipei at Lee and Lee. And he's currently director of the Centre for Corporate and Financial Law at National Taiwan University, or NTU. His main areas of research are business associations, financial regulation, business transactions, and economic analysis of law. And he's a prolific scholar in this field, having authored 10 books and over 100 papers. So we're really grateful that you found the time to come and visit us in Melbourne, Professor Wang, and I'm going to pass over to you now to talk about this fascinating topic. Thank you.
Thank you, Professor Hill, and all the audience for attending. Today I'm going to talk about, the topic is enforcing corporate control law in Taiwan. Basically, I'll conduct several case studies. A little on background. This is an article in progress. It was supposedly become a book chapter for a Cambridge book. I think the editors are from NUS, from Seoul National University, blah, blah, blah. Okay, so this is a book chapter. And the title of the book is called Corporate Scandals in Asia. So as you can imagine, we're not going to talk about, the glorified issues, the stories in Taiwan. Well, each of us is supposed to write something a little bit negative on our respective jurisdictions. Okay, so my article and my talk today I'll focus on one aspect. That's the enforcement issues encountered, especially in corporate control disputes in Taiwan. Okay, so my presentation will be divided into 6 parts. Due to time constraint, I'll try to focus on, I've discussed several cases, but I focus on primarily the case of Tatung. Okay, so that's, secondly, there are many issues involved, but I'll try to focus on some issues which are more like easy to understand, which are also important. And number 5, I primarily talk about, when we talk about enforcement issues, people invariably try to make a distinction as to what kind of methods for enforcement. It could be public, it could be private. In my mind, this is kind of confusing distinction. And after all, especially in the case of Taiwan, if you look at item 5 of my talk today, I'm going to talk about for enforcement of corporate law, the government invariably will play a role. But as all of you know, that in the United States is purely private because U.S. has this leading counsel, have this a very market-oriented type of enforcement mechanism. And I would like to point out, like in Taiwan, we have a unique investor protection center. So in my following remarks, I try to focus a little bit on this particular animal because I thought it's very interesting. It's probably it's the only one in the world. Okay, then I'll conclude by some remarks. First of all, a little bit of background on the thesis or research motivation of this article. Corporate control disputes in Taiwan are quite often and expose weakness in enforcement of corporate law. I think in terms of the landscape of Taiwan, in terms of the market for corporate control, supposedly it should be very stable. Supposedly there shouldn't be too many disputes take place. Why is that? First of all, Taiwan is not like the United States. You know, we don't have the government actually has a policy try to discourage hostile takeovers. And secondly, the government try to put up promulgate rules, try to make the controlling shareholder live easy life in the sense that there be very few opposition shareholders try to take over the company. I think probably in the minds of now, it's not only the minds of policymakers in Taiwan, probably in Asia in general, Asian countries, hostile takeovers or like dramatic fights, contests for corporate control is not something to be desired. But in Taiwan, in certain areas of law, this kind of disputes happen quite frequently. Okay, so my question is, why do corporate governance mechanisms fail to prevent entrenchment and controlling shareholders? And in my talk, I will focus on civil remedies. And the central argument is that weak enforcement mechanisms enable management to maintain control. Okay, so first of all, the first thing I want to explain is talk about the very general background. Okay, first of all, in terms of the civil law, continental common laws distinction, basically Taiwan adopts the continental civil law system, pursuant to which we emphasize statutes over judicial precedent. I think all of you know that. And secondly, however, in terms of commercial laws like corporate law, it primarily has been strongly influenced by the United States. So there's our company law, Company Act, which was modeled on the U.S. system. Okay. And the funny thing is, we belong to the continental civil law system, but on the other hand, being influenced by the U.S. corporate law, right? But there's a unique aspect in terms of our legislation, which is that due to influence of traditional Chinese culture, legislations in Taiwan emphasize brevity or even elegance, sometimes at the expense of clarity or expense of it's a total clear. It's not sometimes it's not very clear. Let me just give you one example. The Company Act, okay, this is the law governing all corporations or including listed companies, right? This act consists of approximately 45 short articles. Many of them are very short, okay? One example, Article 23, Paragraph 1. This is arguably the most important provision contained in the corporate code of almost every jurisdiction, which try to govern or regulate fiduciary duty. Okay, what is our duty? What are duties for key persons, and what are the contents, things like that. So it is a provision on fiduciary duty, which covers both duty of care and duty of loyalty, consists of 43 Chinese characters only. Very, very brief. Why is that? If you make a comparison between laws of Taiwan and laws of China, this particularly be interesting. China, because of, as you know, if some knowledge of Chinese language used to be, it's a love heaven for people who write to points, right? Can be very, very elegant piece. But that has some drawbacks, right? So that's why Chairman Mao, after 1949, he sort of initiated a major reform on Chinese language, what we call 简体字, right? The simplified. So if you read the Chinese law, the equivalent of Chinese fiduciary law, duty, very different. In all minds, because I'm someone who was trained on Chinese, classical Chinese literature and language, right? In all mind, the way Chinese laws, as of today, are written, kind of vulgar. It's very, it's not doesn't fit our traditional, the language style. But I have to say, it's comparatively speaking, it's clearer. It's easy to understand. There's be less loopholes. So this is interesting, for those who are trying to compare just the legislative style, the language style. It would be interesting. Okay, so just give you a sense of this. So in Taiwanese company called Act, basically fiduciary, it's 43 words. Try to cover fiduciary duty. As you can imagine, the act is like many other acts, is full of loopholes and ambiguities. Okay, this is the first one, the first takeaway I want you to have. And secondly, as in the case of many other jurisdictions like Korea, has Chabao, right, and then Japan has this main bank system, blah blah blah. In Taiwan, we don't have that, but we have over 95 of our listed companies are controlled by minority controlling shareholders. Okay, most of them are like family control firms. Okay, so and many of them are from even like groups, underneath parent company, blah blah blah, things like that. So on average, the minority controlling shareholders typically hold from 10 to 30% of all the shares. Okay, so when we talk about listed company, public company in Taiwan, you can say almost with maybe a few, 5, 10, 95, more than 95% are companies with the shareholding structure of minority controlling shareholder from 10 to 30%. Okay, so and outside minority shareholders are not protected well, basically. One example, up to this point, very few derivative suits. So why is that? Because the incentive problem, the procedure for filing derivative suits are kind of tenuous, right? And also there's no incentive for one to sue a minority shareholder to bring suit because you have to pay a lot of court fee, right? And provide bonding, but you don't share the fruit of the derivative suits. Okay. So, because as you can see, like up to maybe 10, 20 years ago, when we talk about corporate governance, talk about protection minority shareholders, it's zero, no protection, practically speaking. But the landscape started to change, I would say significantly, because in 2003, Taiwan government published a law, a complicated law, but the law, one feature of the law provides the establishment of the Investor Protection Center. So later on, I'll try to focus on this, which also relate to our case today. Okay, let's get back to the topic. We're talking about enforcement, right? I check, leading textbook authority. Let's explain public versus private enforcement, but this is not really, doesn't make sense. In essence, I think I discussed this issue with Jennifer the other night. I think we all agree that when we talk about enforcement of corporate law, ultimately, the enforcement thing has to be resolved by the court, mostly, or arbitration, blah, blah, blah. In other words, even in a jurisdiction which is considered, as characterized by so-called public enforcement. I think the governmental agency, as powerful as they may be, would have a hard time to really push the wrongdoers all the way to the end and try to penalize by its own power. There's no way, because most often it will be enforced by the court.
Can I ask you a question?
Yeah, sure.
I'm just interested that you put the UK system as a public enforcement system for directors' duties, because I think of it as a private enforcement. I think of Australia's one where the regulator enforces as both public and private, because you can, shareholders can bring derivative suits. I mean, I would have thought in the UK it's a private enforcement model where it's shareholders bringing the suit, but they just never do.
Yeah, first of all, I didn't come up with this distinction, but let's, according to some literature, compared to the United States, where it's purely private, right? It's purely private market initiated, right? The leading counsel, blah, blah, blah. But whereas in the UK, the UK public agency won't have the ability to enforce, to issue a judgment. But on the other hand, it does have the right to initiate enforcement action, right? So is it true?
Well, it's making me worried that I'm saying the wrong thing in a recent article, but yes.
But is it my understanding correct?
They don't have a system like we do, where there is a regulator tasked with enforcement.
But in Australia,
yeah,
government agents do have the authority.
We have both private, that shareholders can bring actions, but they generally tend to be in the private company context. And then the public regulator, the Australian Securities and Investments Commission, tends to bring actions predominantly, I guess, for breach of duty of care in public companies. Jennifer Varzali has written on that. I've got a second question about this slide, if you don't mind being, So I'm thinking this Black and Crackman article, that self-enforcing model, was that a general model they were putting forward, or was that just in relation to Russia post-privatization?
I think I read the article, right? It was kind of famous, 1996.
Yeah.
I think they advocate a self-enforcement model, which will be applicable to all countries with dominant shareholders.
Really?
So I think that's their thesis. Of course, in terms of the background, they published the article because they were trying to work out, draft law, corporate law for Russia. That's true. Yeah. But I think in the article, they try to advocate this general applicability of the model. And he says something like, for example, the law should, in all these jurisdictions, developed country, with dominant shareholders, it's difficult to enforce. And to have the judiciary branch to enforce the law. So they will advocate for example, cumulative voting.
Yeah.
And blind run rules for example, if a minority shareholder, if you are a shareholder, you manage to have accumulate more than 50% of the shareholding of the company, you are automatically, at least you don't have to talk to the court. Or you are, by operation of law, you are entitled to hold a shareholder. Meaning, this is just one example saying, wow, you can bypass the court.
Yeah.
Right. So that's the thing they argue.
But that doesn't seem to, deal with a shareholder-controlled company. It seems to give them even more rights. But it's many years since I read that article. But I thought what was really driving it was the fact that after privatization in Russia, it all happened so quickly because of the people that were worried communism was going to come back, that they hadn't built up their judicial infrastructure. And I thought it was, they said, oh, well, there won't be any courts to make, dispute resolution. So we're going to make the shareholders the mechanism that decides on disputes and is self-enforcing. And I was always amused I was amused by two things at the time. Firstly, I was at a conference where a Russian stood up and said, oh, well, your model is that the shareholders will make this decision in a shareholder general meeting, but as well as the courts not working in post-privatization Russia, the other thing that doesn't work is the postal service. So your shareholders will never actually receive the notice of meeting. So that was one thing about that. But the other thing was we actually have a system very like that in Australia for related party transactions. It has to go to the shareholders. And so, it was being presented as, oh, this is for a jurisdiction that's completely hopeless in terms of, having any dispute resolution mechanisms in the courts. But, I take your point that they were perhaps saying...
Yeah, but I think let's not argue about that because I think this model is kind of naive, unpersuasive. Yeah, I think that because, as I will try to illustrate later on, because I mean, as long as the dominant shareholder, if he is in a position to abuse, to distort the law, to abuse his power, I mean, now this will work. Nothing will be self-enforcing. Okay. So I think what important is really, we discussed a little bit, how to initiate enforcement. We're not talking about whether we should go to the court. I think invariably, most sensible way to resolve corporate dispute, you have to have the good judicial system. Otherwise, it's very difficult to have a replacement or surrogates. That's my natural system. So, but what's important really is, let's not forget about it. We agree that judicial remedies are important. The role of judicial branch is very important. We all agree that. But what can be the problem is how to initiate enforcement action. For example, you just mentioned that in Australia, government agency can initiate, right? In the UK, dubious, right? Yeah, okay. But I don't know, in the United States, primarily, right? Primarily private initiative. Okay. So the point here is, this is important to really to determine, to figure out how to initiate enforcement action. Okay. Okay. I will just due to time constraint, I'll just basically I will below I will just focus on two aspects. One aspect is the role of the judicial. Okay. How the court in Taiwan react or handle corporate control issue. And secondly, I will talk a little bit about the role played by the government. Okay, when I say the role by the government, there are two issues. One is by the full-fledged Ministry of Economic Affairs, which is a governmental agency in charge of the Corporate Act. How will this government agency react to dispute? And secondly, I'll spend some talk about international Internet Investor Protection Center. Okay, that's I think is interesting. Okay, so next, the Tatung case. I think we can easily skip here. Okay, in the year of let's review. Big issue one. The role or the function or the effectiveness of the judiciary. Okay, what happens in the 2000? This is a company called Tatung, a family control company for 100 years. Okay, in the year 2017, the company make an announcement that we'll have a board meeting election. Okay, in Taiwan, it's election of no staggered board. So it's you have 9 seats, you have to replace one time. Okay. So it's kind of mental alignment dance for all the people who want to play the game. What happens is that we introduce our corporate law, introduce this independent director system, pursuant to which all listed companies have to have a nomination system. You have to nominate, right? The dominant shareholder has to nominate the state or the candidate, so does the opposition party. Okay, so in the year 2017, the election of the next board of directors is coming. The opposition shareholder manages 3 out of 9. So the opposition shareholders managed to to nominate 3 candidates, all big shots.
When
Okay?
you say opposition shareholders, you mean like activist shareholders?
Yeah,
Or?
yeah,
Yeah,
the contest,
okay,
yeah, the
yeah.
contestant, not the dominant. The dominant, of course, they have for 9 seats, they nominate 6 insiders, 3 independent directors. Okay, that's for insiders, right?
Yeah.
But the opposition party, because they have accumulated some shareholdings, so they nominate like among in addition to 3 regular director, there are 3 independent directors. Okay. What happened is that the law at that time says something like, okay, look at the in 2017, or it should be 2017. The law provides that board of directors is required to review all the candidates, including relevant documents submitted by the opposition shoulder. Okay, what happened was that the board at that time, the board controlled by the dominant shareholder, just disqualified the 3 independent director nominees. What was the basis? Let me just give you a dramatic example. I nominate Professor Jennifer Hill on Monash to be independent director. Okay, for the opposition part, for the opposition shareholder, right? The dominant, the board in control, say, just dismiss, disqualify you. Why is that? Because in your resume, it was listed as a chair professor at Monash Law School, but failed to list that you are also a director for a corporate law center, something like that. Just try to dramatize things. In other words, all the 3 independent director candidates nominated by the opposition shareholder, they provide basic resume. It looks sound, right? But because the law, the statute at that time say something like the ruling party has the authority to review, okay, review the relevant documents, certificates, or resume of the candidates. So the board just disqualified them.
Review is different to disqualify, though. But anyway, yeah.
But anyway, they just disqualified. So that's why 1 year later, the act was amended, which doesn't say anything that the ruling party can review. No review. Just say that, if you are opposition party, you want to nominate candidate, you can do that. You should provide blah, 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 this, that, resume, certificate, blah, 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 diploma, blah, blah, blah. Okay, so this is kind of a very minor issue. Just the law says you can review, but the thing is, I mean, are you in a position to misinterpret or abuse or distort the word review? Can you do that? But never. But in any event, they just insist they do it. They did it. So, what can the opposition shareholder do? Nothing. They can bring lawsuits.
Yeah.
Okay, that's the only thing they can do, right? Okay, here, February 17, 2017, Tatung announced a plan for election, right? And 1 month later, the board disqualified someone like Genevieve, due to insufficient candidate information. Just like a very minor detail, like forgot to provide your report card for the elementary school, blah blah blah, things like that. It's ridiculous. Everybody take it as a laughing stock. But what was the remedy? Okay, so no surprise. So during the actual shareholder meeting for board re-election, right? The controlling shareholder with affiliated with the Lin family successfully maintain control, taking all 9 seats of the board. Okay, so this is dirty game, but it works. So there are many litigation, followed. 2018, 2019, 2020. No resolution. after 3 years. Okay. And the legal debate was something like, bear in mind, this is something misconduct was done by the board, right? By the controlling shareholder, the board. But it was the shareholder meeting who elect the directors. So what would be the remedy? The remedy, so the court, the different layers of courts, judges debated about how to classify this issue because under Taiwan law, when we talk about remedy, I mean, supposedly you should sanction, you should penalize the board members who disqualify the candidate, right? But since if we don't do that, but what they call distant water would not put out nearby fire, right? That's a long shot. So the court deal with this the shareholder meeting thing. But even for that, I think the judges at different level courts, they have argued with how to classify the issue because under Taiwanese Corporate Act, you can argue this is something about in violation of something by corporate law. That's the heart of the corporate law, so it should something be nullified, right? Or it is something voidable because this is a minor mistake. It's something, I think basically I would not take too much time to argue about the legal nicety here, but basically what I'm trying to say is after 3 years, full 3 years, the different series, different position. I think the judges argued about the nature of this violation and how to provide remedies. Basically, they cannot come to a conclusion or consent or cannot reach a consensus. So you know what? After 3 years, if this judicial remedy cannot be provided timely within 3 years, what will happen? It will become irrelevant because after 3 years, the next round of election would take place, right? So the court, it doesn't, whatever the court says after the year 2020 doesn't make a difference. So the court didn't reach any concluding opinion about this particular suit. Okay. And how about the preliminary injunctions? I think again both sides apply for for example, the opposition party, opposition shareholder, they argue, they propose to court, to issue a preliminary injunction, to try to remove independent directors elected, in 2017, which were affiliated with the controlling shareholders, of course. Okay, so both sides petition for preliminary injunctions. But again, it does not produce any concrete results. Let me just here, I just give one extreme example. Because even if I'm the controlling shareholder, if the court says impose an injunction on me, say, no, I should, we should remove the independent directors illegally elected. I can just don't give you the shit. I can ignore you. But in one situation, in one case, whereby the opposition shareholders petition, after they petition, the court managed to order the board to include the two excluded proposals into the agenda and recall. In other words, the opposition shareholder tried to petition for the court to sort of install the two independent director nominees, which has been included. Try to install that into the board. It's difficult, right? But anyway, in one situation, the opposition, the controlling shareholder simply just ignore the court orders and look at the last item. The court, in one situation, just say, try not to impose too draconic, remedies over this situation, just impose an administrative fine on the companies and responsible persons. The point is here is really that even for injunctive relief, the court seems to be unable to really push the injunction all the way to the execution. The best they can do is really to impose an administrative fine. So in other words, I think in a lot of developed countries, including Taiwan, I think the power of really, when we talk about judicial remedies, when we talk about injunction relief, I think in many cases, the court will have a hard time to really put through to push the execution of the court order. Okay, so I think that's one of the difficulties. Okay, I will just okay, big review. I'll talk about Tatung case, talking about 127 election. And the election was obviously because of the distortion made of the interpretation or misinterpretation of Corporate Act, right? But in light of that misconduct or misinterpretation, when the opposition shareholders tried to seek remedy from the court, it took the court more than 3 years. No result. Okay, for injunction relief, it seems to me that the court didn't have tools to really put it through. Okay, that's the first story. Okay, that's stand wrongful. Okay. Okay, scenario 2, still we'll focus on Tatung, right? Today we can only go for Tatung. Last story we talked about this illegal or unreasonable disqualification of candidates, right? Okay, in the year of 2020, right? So the Tatung is faced with a new re-election, and the market, the opposition shareholders become more powerful. The opposition shareholder accumulates, more and more shares. Actually, according to unofficial statistics, it has accumulated more than 50% of shares. So it looks like that if the forthcoming shareholder is duly held, it'll be easy. It'll be a piece of cake for the opposition shareholder to take over, right? But what happened during the shareholder meeting? The chairwoman, who of course is chairman of the shareholder meeting, right? With good lawyers sitting beside her. What did they do? They say, well, we are in the process of calculating, right? Who has the right to vote? Shareholder, right? The lawyer, based on the advice provided by the very able lawyers, wow, we have a new findings today. What's that? Maybe 6 or 7% of some of the voters, some of the shareholders. Looks like they are legitimate shareholders qualified to vote. But what happened is our lawyers provide ample evidence that these shareholders, actually, we strongly suspect that these shareholders actually are invested by Chinese, by PRC people.
Is that
PRC offshore capital, PRC offshore company. We provide, this is, by the way, this is kind of in violation of Taiwan law, which says foreigners or PRC citizens are not allowed to invest in Taiwanese public companies. But of course, in terms of the legal effects, the law was not elaborate. It was not elaborate enough to say if you do, your voting rights will be deprived. It's not that clear. Okay, but Taiwanese Taiwan doesn't have a law. Say something like it's no good. You know, if we don't allow PRC citizens to make investment in Taiwan British company. Okay, so the chairwoman of the shareholder meeting, you know, with the assistance from able lawyers, present some of the documents. This is from Red China. So that's why I say a lawful investor from this is a big issue. Everybody's like raising the eyebrow, right? It's like, wow. So maybe 75% of the shares are disqualified. Okay, they're not disqualified vote. So, of course, what will be the result of the day of the election? Of course, the Lim family, again, you know, have control over the 9 seats. Okay, this is a clear violation of the law, right? So what can do? Well, actually, by the way, after this incident, we amend our law again. Say something like, if you can prove you can, if you're a minority shareholder has the more than, you know, opposing shareholder have proof that you can hold more than 50% of the shares, then you can hold the shareholder meeting all by yourself. Okay, so in that time, so this amendment was trying to solve the problem that before. Okay,
Sorry, how many shares does the shareholder need in order to convene their own meeting?
Used to be it has to be no, only the board can hold a meeting, with exceptions. I'll tell you about this particular section. So previously it was extremely difficult. It was, you know, if corporate governance work well, then, you know, the board would call meeting every day, every year, right? But other than that, it's very difficult. Okay. But now, after 2020, after this incident, the act was amended to allow shareholders who hold more than 50% to hold the shareholder meeting all by themselves. Okay, but this is the new law, which is not applicable.
What is it in Australia? 5%. You can convene your own
How many?
meeting.
How many?
5%. 5%.
Well, that would be two. I mean, so they can easily call AGM.
Yeah.
It used to be that 100 by number could call an AGM. So you could walk into a pub and say, who wants 99 shareholders? Here you go. We're holding your shareholders.
You know, as I do, you know, it's a big thing for a listed company to.
Well, you know, we're a very different capital structure to Taiwan. So, you know, it's only really big institutional investors that would be able to.
You have this dispersed. Interesting. Now, so what if you are the opposition party or opposition shareholder? What can you do? Okay, I find Article 173 of the Corporate Act say something like, okay, if you are a shareholder holding more than 3% of shares of the company, you are entitled to request the company, to file a request to company to hold the EGM. More than 3% you can hold. Okay. Do they have 3%? Of course they have. So they file a request. But what was the response? Just total ignorance. Totally ignore, right? I don't give a shit to this request. Okay. Article 173 follows by saying that if you are 3% shareholder, if you file a request and be ignored, then you can file application with the Ministry of Economic Affairs. This is the agency responsible for enacting or implementing the law. Okay, so the law says that. Now I've tried to let me see. Okay, the law says something like here. There's something where, like, you know, if you file a request and which has been rejected, right? Understandably being rejected, you have the right, you have the opportunity to file application with the Ministry of Economic Affairs. And upon approval by the ministry, you can hold. Okay? So that's easy. I think in the minds of general public, this case in Taiwan has become headlines every day. It's a big case, big cases. Okay, so the law is according to the language. The statute seems pretty clear. Like if your request is being refused, right? It declined. Then the ministry has the authority to approve. Then the ministry did approve. Then the opposition shareholder will successfully hold a meeting. Okay, that's no problem. But at that time, many even scholars, they speak on the side of the dominant shareholder. They were saying something like, look at the statutory language. The approval is controversial because the statutory language is vague, which said in effect, an EGM should be approved whenever the board does not convene a meeting upon request. In other words, in a long history of corporate act in Taiwan, 50, 60 years, there are very, very few cases which apply this rule. Why is that? Because the ministry, in a long history of its practice of corporate law, they try not to get involved in this. They seldom approve, despite the fact that a lot of this application has been filed. Okay, but for this particular case, the ministry, of course, its public opinion was strongly against the Tatung company, right? So it's easy for the ministry to say, okay, I approve. But the point, I think that the people argue about that, this language is so flexible, right? So why you didn't issue approval? I mean, for many, many previous equally or even, cases like that.
One of our people online has a question, if you don't mind.
Yeah, sure.
We've got about 12 minutes. Are you happy to take some questions or?
We have 12 minutes.
But we want to ask you questions. It's fascinating.
You are the chair, right? So yeah.
Let's have a couple of questions.
Yes, go ahead, Eugene.
Thanks, Tamara. Thank you, Professor Eugene
Can't
Teo
hear
from
you.
the
Hang on.
University of.
One moment.
Could put it in the.
We don't like that.
No, it's when we've got both. Maybe put it in the question box.
Yeah, let me just.
While Tamara's looking at that, I just wanted to mention the failure, if that happens, that the shareholders want to convene a meeting and the board is ignoring them. There's one provision where the shareholders go to the directors and say, we want to convene a meeting and we want you to do it for us. And if the directors ignore that, the disincentive for the directors to do that is that the shareholders are entitled to convene the meeting on their own and the directors have to pay the costs of that meeting out of their own pocket. So that's kind of a good financial incentive. But shareholders can only do it if it's for a legitimate reason. Shareholders also have their own right. I think it's again 5%, but to convene
approval.
No, doesn't need court approval. Shareholders can also convene it themselves if they've got the requisite level of shareholding. But if they do it themselves, as opposed to getting down on bended knee to the board, the shareholders have to pay for it themselves. But we had a situation 2 years ago or 3 years ago in relation to AGL, and Mike Cannon-Brookes wanted to put up 4 independent directors that were more involved in climate change, and the board really did not want that. But the board, the most they could do was to say to shareholders, you shouldn't approve this, because these people, don't have the right credentials, or, they couldn't veto it going to the shareholders. And the shareholders, I think, ended up appointing 3 out of the 4, or maybe all of them. Anyhow, but it was a similar sort of situation.
Yeah.
So do we have our question yet?
Yeah, Eugene, I think you should be good now, hopefully.
Okay, thanks a lot, Tamara. Thank you, Professor Eugene Teo from the University of Melbourne. My
Oh, okay.
question is, what's the law of legal professional privilege in Taiwan? Because in Australia, if the chair had said we have taken legal advice and are acting on it, they would have been taken to have waived privilege over their advice and they'd legally have to disclose it. So interesting that the chair there actually said we are acting on legal advice because you probably wouldn't say the same thing here.
Yeah, I think I hope I got your question right. I think this is interesting, good question. I think for the 2020 shareholder meeting, of course, as I say chair lady was chairing the shareholder meeting with the system from lawyers, right? The lawyers, they are maybe three or four law firms, mid-size, small-size law firms, high-profile corporate lawyers. They are doing this. I think in the reputable firms would try to get involved and try to give opinion like this. But there are several famous lawyers. They are trying to. I think what they do is give a very arbitrary interpretation of law provide the legal arbitration interpretation to the client, which result in, say, investment on China, so it should not be counted, should be qualified, blah, blah, blah. I think after this particular incident, I think the members of Taipei Bar Association did discuss, where should do how, where should to do something about it. I don't see a concrete result for this particular case, but I think they have been, especially for this kind of corporate contests, the stakes are so high that the person involved, they will hire high profile lawyers and get kind of dubious legal advice. This happens once in a while, occasionally. I think people talk a lot bit, but I think as to formal sanction imposed by the professional association, they are probably very few. I think that's explain why I think in Taiwan there are big shot lawyers trying to make a lot of money by representing these kind of clients, meaning they give dubious legal advice, I would say, right? But bear in mind, my first page was saying something like the law in Taiwan is written in such a way that is right, to be taken advantage by people who are innovative.
But
Okay.
Eugene's question is interesting. I don't know anything about legal professional privilege and waiving it, but just this idea that because you make an announcement as chair, that you're acting on legal advice. If I understood you right, Eugene, that would in itself amount to a waiver under Australian law. Yeah.
Usually.
And would it amount to waiving professional privilege under Taiwanese or or in other
We don't talk
jurisdictions?
about way. I mean, that's too sophisticated for us. I think in Taiwan we talk about this political lawyer. I mean, when you give a piece of dubious advice, legal advice, right? Is that something you should do, or should you be penalized, right? I mean, let's yeah.
Yeah.
Okay, I think the last item probably the most interesting. This is sorry, it's not moving. Oh.
Sorry, I'm just going to put this.
Okay.
speaker
I want to talk a little bit about this Tatung case. One is it's not working.
It's good. Yeah.
Yeah, it's good.
No, it's not. You think?
How much time do I have?
Not much. 5 minutes.
I think it should be working out, right? Yeah,
There we go.
Yeah.
One issue with Tatung, the chairwoman, she was going too far, right? And something has to be done about it. The all corporate law, I'm talking about removal or disqualified. Now, he has done something wrong. He should be removed. That's one way of enforce corporate law, right? In my mind. Okay, at that time, the Company Code Act of Taiwan said nothing about removal of nobody can initiate a removal action to the court. Okay. But as I say, since 2003, Taiwan promulgated a law, which basically the government would say create a separate individual government-sanctioned nonprofit organization called the Investment Protection Center. This center is ostensibly is a nonprofit, but in terms of appointment of key person, appointment of shareholders, but appointment on directors, appointment CEO are all made by the government. Okay, and also this center has a lot of funding. This nonprofit organization has a lot of funding. Where does the funding come from? The law through mandatory rules saying that all the security firms, all the people controlled by the government, they are entitled to donate. So as a result, the center has a lot of funds, and also the key persons are appointed by the government, and also the center is provided in law that has a specific privilege as to reduce the court costs. You pay less. You don't have to pay court fee, or you pay less court fee. And also in terms of some privilege in terms of injunction relief, blah, blah, blah. So as a result, in Taiwan as of today, we have a mistreated animal, which on the surface is a nonprofit organization, but in essence is created by the government. And as I say, 30 years ago, we had zero investor protection. But since the establishment of this IPC, a lot of remedies, because this center has the power to bring a lawsuit to the court to remove unqualified board director. Like in our case, the Tatung case, the center filed a lawsuit with court, and the chair lady was successfully removed. Okay, so this is basically our case. But what I want to say, at this time they are actually my cases. I think I just want to say they are more. The center has more power. Has power to file suits against wrongdoers for financial fraud, for market manipulation, for breach of trust, or for breach of fiduciary duty, blah 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 blah, for that. So now, as of today, because of since the establishment of the center, in terms of protection of minority shareholders, it's becoming quite substantial and made some substantial contribution. But as to how to evaluate the function, this is a fascinating topic. I wrote a couple articles about this, and but we don't have time for that. So just want to know that maybe I can elicit your comments as to what's your initial reaction. Is this good? This it looks like with this establishment of this center, you have the best of both worlds, right? Public and private, right?
Yep.
But can you detect any disadvantages? Any problems, any way that may not work so effectively in certain aspect? So that's interesting.
Well, we need to think about that, and we can talk about it later in the day. And
Yeah.
But if I could thank everybody that was either here in person or those of you who joined online. And thank you, Professor Wang, for a really fascinating case study and comparative law analysis. Thank you so much.
Sure.